I hope everybody has to view my slides also. Yes or no?
Yes, sir.
Okay. My dear students,
Yes,
this is
sir.
the class of four and fourth number class. That is the subject is IBO-1 block number 4 and the topic is legal environment. And myself, Dr. Durga Madhav Mahapatra, lecturer in commerce, Fakirmon Autonomous College, Baleswar, as well as counselor of Indira Gandhi National Open University, New Delhi. In front of you, I am presenting the related subjects or related units of legal environment. My dear students, as you know, in a business environment, there are different aspects are there. External environment, internal environment is there. Among these, one environment is totally affect on a particular business that is called as a legal environment. The question is, what is legal environment? In layman's point of view, you already know that is called as a rules or regulations or procedures or formulation through which two countries are start their business operation and with some sort of marketing strategy they can maintain abide by the some of the rules and regulations. If you send or exporting of goods or importing of goods, some of the rules are there, some of the guidelines are different from one country to another country is there. In this connection, I want to say the laws of land is directly affect the international business wherever they operate. Means every international business manager should know about the legal regulatory framework of the international business orientation or may be called as various foreign countries or in relation to the home country or as well as host country, how the laws are to be dealt, that dealing of attitude should know by the international business manager. My dear students, here legal environment means first of all we know what is law, and laws are different types. Even if some of the countries you may say, as earlier I stated, developed countries, developing countries, or you may call it as a that is underdeveloped countries. Every countries have an abiding by the rules and regulations that is called as a law. But the question is, law means there are different types of legal systems are to be adopted by the different countries. If you take if you take the kinds of legal system, there are generally three types of legal systems are there. One is common law, another one is civil law, another one is the theocratical law. The question is common law. Common law means it is based on tradition, customs, culture, precedent, or any uses on a basis of common basis. These type of laws are to be framed out in a particular countries, not only a particular countries, it's based on some of the traditions is there, customs is there, or with due respect of culture is there. Some rules and regulations are to be framed out, some situations, some incidents are to be arises. That type of law is called as a common law. And if you talk about in USA, UK, or Hong Kong, these laws are very much famous, and that laws are called as a common laws. My dear students, another law is the civil laws. We are dealt with in every day of our life. Civil courts and detailed set of laws which are to be or some set of codes on the basis of civil laws are to be framed out, and how the law is applicable to some of the facts and incidents. Such type of laws are or example of contracts should be in detail in regards to the different countries are focused on the or in coverage with the or aspect with the civil laws. If you talk about countries like France, Germany, Japan, they follow the civil laws. As well as in India also, we are also following such type of laws that is called as civil codes. Or it is another laws called as a theocratical law, that spelling is THEOCRATIC, theocratical law. It means it is related to religious laws. My dear students, religious laws means we are always based on some Muslim laws are there, Muslim code of conducts are there, or Muslim laws, Hindu laws are also there, and that Islamic laws is almost famous in Muslim countries. In India also, there is a Hindu law is there, and if you talk about Holy Quran, that's related to some of the laws is affectionate with the particular Muslim countries. And if you talk about the Prophet Muhammad has said some concept and regarding the laws that to be put through the Holy Quran. Means, my dear students, theocratical law is based upon the Muslim countries, as well as some of the laws related to Hindu laws is related to in our countries also. But the question is, all countries, whether developing, developed, or underdeveloped countries, all countries abide by the some of the rules and regulation, procedure, guidelines to do their business. Do their business means that's called as the international orientation of approach of business. It is, for example, if you talk about the business, you may say there is a communism to market economy, or mixed economy to market economy, or democratic to capitalism. That type of environmental attitude knocks our mind to do a such type of environmental aspect of the economy of a different country. My dear students, if you talk about China, there is a the great problem which arises at the time of the owner of Alibaba and with China government. There is some of the principle is lacking behind that such problem which arises. If you talk about in India also, some companies means, as in today, if you read in today's newspaper, now POSCO is welcoming by the Odisha government. But once upon a time, POSCO is reluctant to do or start their business at Odisha also. The question is why, and what is the purpose behind is not considering their business opportunities, not only by the Odisha government, but also some issues which are already I am stated by the China government regarding to the owner of a Alibaba. The question is here only one term that is called as a legal issues. And today's class for discussion regarding the legal issues. My dear students, this is the class block number 4 contains 3 topics only related to legal issues. First, unit 14 is the legal environment of foreign trade. Unit 14, that is proper law of contract or the lex quasi, and unit 16, that is settlement of international trade disputes. Sometimes trade disputes are to be settled, some of the issues are to be carried out. My dear students, if you see in my slides, in unit 14, that is legal environment of foreign trade, the question is law. Already I have stated the laws are different types of common laws, civil laws, or theoretical laws. And these laws are called as the rules and regulation principles, or one definition say that is a rules of external human action which are enforced by the state, that is also called as a law. But the question is, here we are discussing the international business as relates to law. It means all legal environment. So what type of legal environment or issues are to be addressed upon? Only 3-4 acts are coverage under the international business. One is Indian commercial law is also statutory. One is the Contract Act 1872, the Sales of Goods Act 1930, and the Partnership Act 1932, and the Companies Act 1956, and later on it is amended at 2013. My dear students, but even if these acts are more conscious enough to do a particular type of international business scenario, and with a legal system of laws are in force with the foreign countries, but there are two important acts are important. One is the Contract Act, another one is the Sales of Goods Act. One by one we have to discuss. One is contract. Contract is necessary in a international trade and transaction. These are the legalized one. This is regularized through a contract. Without contract, no international trade transaction cannot be focused on. So the contract, one theory is arises. The what is the question of what is contract and what is its functions? Means the contract which is the agreements which are enforced by the law is known as contract. It means contract is equal to agreement plus enforceability by the law. Means once one word says, if you talk about one word, that may be called as a if you talk about one word, that is called as a the all contracts are agreement, but all agreements are not contract. All contracts are agreement, but all agreements are not contract. The question is, another concept is related to export and import. I have already stated in the last class what is export, what is import. But the question is export sale contract. Here I am attaching with the export sale contract. Is applicable to the law of exports or related to imports, or begin with the all international transaction. Means ESC is a important or legal contract through which the all import and exporting of transaction can be focused on in international trade and commerce. Means all export transactions are legalized through a contract called as a export sale contract, and all exports contract, all imports are also legalized through a contract are called as a import contract. Means ESC, another one is ISC. ESC means export sales contract, import means import contract IC. These are the two issues are to be focused on international business. Only main objective is only the transferring of property, transferring of goods, transferring of services with a legalized manner. But the question is, contract is necessary, and it's a relation between the exporter and overseas of importer also. And at a conclusion, I can say ESC are a distinct of a different contract, although it is related to ESC. Means a export sales contract or export contract or import contract are two important points through which the international business operation can be made successful. Another one is, if you talk about that is called as, if you talk about of PLC, it means that is called as a the proper law of the contract. Later on we have to discuss detail in detail. Means these are to be also related to a contract. What is proper law of contract? I have to discuss in later on slides. and then only we have to basically focus if you enact to do with the different type of non-contractual relationship with the foreign trade. There is some issues we are pointed out, that is Foreign Trade Development Regulation Act 1992, Foreign Exchange Regulation Act, Customs Act, Custom Tariffs Act, Pre-Shipment Act, Quality Control Act. Means there are different types of acts are there, or various laws are there, which are under the purview of the international business operation. The government are to be more enacted with these such type of rules regarding to the provision of laws. My dear student, if you talk about the exporter as an international agency, there are different other agencies are there. International Chamber of Commerce, ICC. In India also, in India, there is a Indian Chamber of Commerce is there. And but in the international point of view, that is International Chamber of Commerce. And Paris has formulated another convention also, that is called as International Contract of 1990, or UCPDC, and uniform custom practices for documentary credit. Uniform practices should be there. This is related to the exports. If you related to the exporter as a consumer, some directives are there, product liabilities is there, Consumer Protection Act is there, and some directives are there to ensure the protection of the customer. But the question behind is only one thing: why we are more focusing regarding the internationalization of business as relates to legal. Only we have to do the international business very smoothness way through these rules, through this procedure, through these guidelines, and that type of environmental focus on are called as a legal environment. My dear students, if you talk about the laws of contract, as already you read in the graduation level already, every contract which are enforceable by every agreement or promise which are enforceable by the law is a contract, and only one term is called, that is called as all contracts are agreement, but all agreements are not contract. So according to section 10 and some of the free consent parties, section 13 competency parties, law of consideration, law of object, there are different type of laws as related to the Indian Contract Act 1872. Contract is necessary because we are doing the internationalization of our business. Two parties are there, and through contract we can solve enough to do the business. But if you talk about essential elements of a valid contract, that is offer and acceptance, and legal relationship is required, lawful consideration, capacity of parties, free consent, legality of object, and possibility of performance, legal formalities. These are the some of the essential elements which are already in better way at graduation level. These are the some of the valid elements of a contract. Means there are two parties, the offer and offeree. Acceptance, there is a one person who accepts the particular offer, and the offer may be a implied offer. These are the some of the coverage under the essential elements of a valid contract. If you talk about some classification of a contract, it can be classified in a different way according to validity, according to formation, according to performance. If you talk about in a validity, that's it is divided into different parts. One is a unenforceable agreement, means these are not enforced by the court of law or one or both parties. These are called as a technical defect one. And another one is valid contract, which is the agreement which is enforceable by the law. That is called as a valid contract. Enforceable means that is a legal binding. Another one is voidable contract. It is can be avoided by the some parties of the agreement. Voidable and void contract in certain agreement which are valid in the beginning and subsequently it is void. It means due to the some change of rules, some regulation, principles or guidelines can be changed, then the contract is void. Void means it is a You may call as it is not a legally frame out of a particular contract. If you talk about void agreements, similarly, it is not enforceable by the law and it is said to be void and it is no legal effect and there is no right of any person creates no obligations. These are the certain types of contract. If you talk about in classification on the basis of formation, the contract may be express contract, implied contract, and quasi contracts are there. Expressed by what spoken or written, implied it can according to the conduct of the parties, some circumstances the contract is made, that is implied, that is tacit, that is inferred contract. Or quasi, it quasi QUACSI, it means it does not fulfill the requirement, or in strict sense it is not a contract at all. It means it's not called as a contract also. Means another one is that there are different classification according to performance. The performance wise it is also divided executed, executory contract, and some are the one-sided contract or bilateral contract, two-sided contracts are there. There are different other ways are there. But another part of a particular in a legal environment, one part in unit one, that is the unit, first unit, that is called as the Sales of Goods Act 1930. Means there are two persons are there, one is buyer, another one is seller. The person who buys or agrees to buy the goods, that is called as a agrees to buy the goods, or seller, it means a person who sells or agrees to sell the goods, he is called a seller. The goods are also different types. These are the existing goods, future goods, contingent goods, and some of the essential elements of goods are there. Every transaction should be in a price, every transaction should be in a term of contract, and there are at least two parties are there, and transfer or agreement to transfer the ownership of the goods should be there, and subject matter of a contract must necessarily written over. These are the some of the issues which are related to essentials of a contract of sale. But the question is, if you talk about what is the difference of sale and agreement to sell, if you sell means the transfer of ownership immediately to the buyer, a seller to the buyer, and the contract is called as a sale. If you talk about the agreement to sell, means the ownership or to take place at a future date or is subject to some conditional approaches. There are some condition you have to fulfill. That's called as a agreement to sell. Means when agreement to sell is converted to sell, now when the particular fulfillment can be arises or prescribed time period or to be covered up, then the agreement to sell is converted to sell also. And some concept of conditions and warranty are there. Concept of condition and warranty means the goods is related to condition and warranty means it is a sum of purpose of a contract. It means some right to treat the contract as a repudiated also. Means that there is some of the claims are there. It means essential to main purpose of the contract. Warranty means only subsidiary to main purpose of the contract. Mean the if any damages that not be repudiated, but in a condition if the damage arises that can be repudiated. If it repudiated means that can be recovered or that can be you may call as it can be solved through a different type of conditional approach. But the question is another concept is the doctrine of caveat emptor, that is called as the buyer's beware. Before you purchase the goods, you buyers you must check the goods condition, its fitness and its choice, and he may not be blamed to the seller after recovering the damage from him. Means the buyers be aware regarding the description of the goods, title of the goods, fitness of the goods, skill and judgment should be made through the seller. These are some of the issues related to doctrine of caveat emptor, and you have already covered in the business law classes at in graduation. But the question is, these are the some of the in unit 14. These are the some of the coverage as relates to contract, as relates to sales of goods act, as relates to condition, warranty, and some of the issues related to buyers beware, caveat emptor, or related to the some of the laws as related to common law, civil law, and theoretical law, which are to be addressed upon the legal environment. But in unit 15, that one important topic is there, that is called as the proper law of the contract. And the proper law of the contract, or you may say called as the lex causi. The lex causi, what does it mean? It means, if you see in my slide, it is already stated, means you have already learned regarding the different type of in unit 14 different type of contract, which are agreement which is enforced by the law, offer and acceptance, capacity of parties, and consideration. There are different type of points are there, but somehow you also know the export sales contract. Already I have stated export sales contract or import contract as relates to international trade transactions. These type of contracts are based upon the privacy contracts, or to create a legally binding or enforceable the obligation between the parties. Now the question is here, the what is a PLC proper, that is proper law of contract, means some of the international contracts, it involves in foreign transaction or foreign elements between the two parties or parties belonging to the different country have a different legal regime or different laws are applicable. That laws are called as a proper law of contract or lex causi. It means different countries have on different laws, different region have on different laws. With this reason, we are accommodating with such type of negotiations which arises. That negotiations of approach focus on such type of law, that is called as a proper law of contract or lex causa. It means the contract can be domestic contract between the parties belong to one or same with different internationalization way, or different laws are to be framed. I have already in my first aspect, in the particular aspect I have discussed, there are different laws are there: common laws, civil laws, another one is the theoretical laws. In this connection, some legal issues are there, so that the PLC may be the exporter's point of view or importer's country point of view, or in a third country's law point of view, which is related to national laws which are applicable to the PLC. That is called the proper law of the contract or lex causa. The question is, this proper law of the contract, when the choice law of existing for or present the contract, means present the contract, what is the position, or existing or present the contract, or in absentia what happens. The question is, the choice of law present, where it means they have been expressly, it can be focused on, or it can be implied on, it can be select one or choice one to govern the contractual relations. When it is present, it means expressly we can define our contract of the parties, or in impliedly we can define our contract of the parties. It means the select of choice law of a contract, including ESI, and that can be exporters or importers point of view, which is applicable to their contract. But if you see my slide, I am saying if it is absent the contract, if it is absent, what happens? The choice of law clause is not existing in absent in a particular contract, including ESI. Why this happens? This happens only to find out the intention of contracting the agreement or various contract documents, even some applicables, means some of the documentation which are inferred or deducted, or conflict of laws, conflict of principles. Somehow we are not equipped with the other countries' principles. That is called as a, if the some of the intention of a party is applied to infringe with the particular laws, that so happens. And some of the each country has formulated its conflict of laws regarding the overall guidance of a country on this question is issued. It means somehow we are not agree with the some other countries guidelines or rules or regulation frame out, that is called as a in absent of in the country. The proper of a law of the contract, when the choice of law clause not existing or absent in the contract. But the question is, in this connection, the proper law is framed out. A proper law is framed out means I have already stated that is called as express, that is a implied, selected by the parties, and proper law already governs the formation of essential validity, capacity, interpretation of a particular contract, and some of the convention laws is applicable to the obligation is there. And if you talk about in a application to Lex Koja, there are different guidelines as related to third parties there. But however, these are the some of the issues we can focus on the proper law or Lex Koja. Lex Koja means that's called as a we are somehow adjusting with each other of the particular law. In this case, one proper law is framework. Another in the unit 16, that is called as a settlement of international disputes. Settlement of international disputes. The question is why dispute is arises? Why dispute is arises? Why negotiations are to be carried out? Why the arbitration process is focused on? And the question is why particular dispute is arises? Dispute is arises sometimes ago. The IBM entered into the many countries, including France, in view of the strength of the technology, but some countries are not adopting. Even if some of the marketing expertise, like as Coca-Cola, enter into many countries in view of the strength of a marketing expertise, but some countries are arises regarding the disputes. The question is here, why the dispute is arises? Disputes in between two countries transaction mean dispute arises only the contracting parties which do not fulfill the contractual obligations, means breach of contract. It means it is a breach of contract means some point of time contractual obligations are to be breached down, or it can be obligations cannot be repudiated also. Means but why the dispute is arises if the goods are not supplied in a right time or stipulated time? Why the dispute is arises? Now only delay payment of amount, or that's a difficult due to some contingent of event, due to some of the event is arises, and it can be delayed one. Why the dispute is arises? Some commercial impossibility is like rising of raw material prices is increases, freight and hike is freight price is hike, and some exports may be unprofitable one, and some parties is reluctant to do the business in near future also. They are neglecting the such type of trade issues, that is called as a dispute is arises. Another dispute is inability to perform the obligations. Obligation means it is a failure to third person to whom promise to pay, and sometimes unusual circumstances like as strikes, lockouts, and some factory problem is arises. Some like as unavoidable or due to some unavoidable circumstances, these type of dispute is arises. It is very difficult to meet his commitment by the particular person or promiser, or maybe called as a negotiator to whom the goods are to be sent to the other countries. Sometimes some overseas buyers want to avoid the contractual obligations due to the non-demand of the goods, and it is difficult to locate the buyers also for the goods order. Means demand also is a one factor of a disputes. Another one is overseas sometimes delays in payment of the goods, I have already stated, and not supplying the goods in a proper description. For example, in a recent example, everybody know in a Suez Canal is a one via media through which the international business can be focused on. In such a scenario, one ship is totally stable at a 1 week in a Suez Canal, and what happens? That is a huge high and cries are there in internationalization of business. How the ships will movement, and what is the reason behind ship is stop or in between the Suez Canal? So this in this connection there is some dispute is arises, some of the delays and some of the not supplying according to description or not corresponding to according to sample or not purpose required to skill or judgment or dispute may also arises not according to quality. Meaning means the goods are do not have an use of a proper value, means the quality aspect is also a another part of a that type of dispute arises. But my dear students, another some issues are there. Risk is there. Risk means you already know there are risk at two types. One is systematic risk is there, unsystematic risk is there, and which can be avoided, which can be not avoided. And due to the passing of the property of the goods or ownership, some risk and title of the goods can be changed, and some breach of express contract or implied contract. That is also a negative side of a disputes regarding to the internationalization of business or misinterpretation of a proper clause. Proper clause will be misinterpreted. You see in the different medicines, you see some of the countries, for the sharp countries the price is different, and some other countries the price is also different. There is a two pricing method is there. That pricing method is called a transfer pricing. Sometimes transfer pricing means convertible to Indian currency to other country currency and other country currency to Indian currency. That type of issues are to be addressed upon, or more precautions should be focused on in a particular type of internationalization of business. My dear students, you know that there is a in a shipment problem also, including part shipment, transshipment, packing, labeling, marketing. Somehow damaging is also issues of a disputes. But the question is, in a international business, how we have to solve the disputes and what is the settlement method and what is the really settlement method. Are three types are there. One is litigation, another one is arbitration, another one is conciliation. There are three dispute methods are there to resolving the international trade disputes. One is litigation. Here litigation means L, it means laws, means it is a method by which the parties have to be resolved through a court of law or established by the law. Means law is there and law can abide by the in a proper govern this type of international business. Means we are always on such a law, so that we are before we are discussing regarding the law of contract, law of sales of goods act. Another one is a companies act also. Another one is some foreign exchange management act also. Another one is the proper laws or law for proper law is there. I mean, these are those issues relating to the exporting and importing, and so litigation should be completed with the rule of court of law, and proper conduct is there, and that court can decide whether the party's evidence can be made on the basis of the particular litigation. But some litigation is a very time consuming. In later on PPTs, I have to discuss what are the negative side of a litigation and what is the positive side of a arbitration. The question is what is arbitration and who is called as arbitrator. And arbitration means it is a procedure in which dispute can be solved, and it is a agreement of parties. Through arbiter it can be the decision can be solved through that, and it is a one type of resolution procedure instead of going court. Means instead of going court or instead of focus on legal point of view, we can solve through arbitrator, or we have to solve with a written agreement, and we are agree with some of the contract issues, and that is called as arbitration. The basic difference between litigation and arbitration is litigation is related to court of law and arbitration is not related to court of law. It is only the disputes can be solved through a arbitrator is appointed, and it is can a written agreement through which the particular it is a through a voluntary submission of the disputes. In the so arbitrage is there, of one tribunal is there, arbitral tribunal is there, and he can nominated of a counterparties, and we can solve the problem. Means it is called as a you may call as it is called as a quasi judicial proceedings, and without court the settlement can be made. If it is comes through litigation, it's have a longer period of time to solve the issues of international business. Nowadays it is not a one day affairs, it is a number of days that to be taken to solve the particular issues. But my dear student, but the question is, another one is that is called as a conciliation. What is conciliation? One is litigation, that is related to court of law. One is arbitration, that is a friendly affairs. It can there is arbitrator is appointed, or one person is appointed, or one mediator is appointed, for which the international business problem can be solved. Another one is conciliation. Conciliation means this is the third segment of a settlement of disputes. Means the settlement of disputes by mutually and friendly agreement. Friendly agreement, through friendly agreement it can be solved. But sometimes some of the countries are disagree with this aspect of conciliation. Why this arises? Now, due to the territory problem, due to the maritime rights also, maritime trials, or due to the some human right issues also, or due to the some of the related to some issues are there through which conciliation is very difficult. If you talk about the relation with the Sri Lanka's the trade and business, and as well as in nearby the in India, that is called as Nepal, or Bhutan, or some other Myanmar, some issues are there. If you see in today's newspaper, Myanmar is something in a different way. Their disputes are arises in a particular country. But the question, it is very difficult to relate with a particular type of business in between two countries. But the question is, three settlement disputes are there. One is litigation, second one is arbitration, and third one is conciliation. Conciliation can be done by mutually agreed and friendly agreement between the two countries, two parties, and two promisor promisee. Any if you anything you can say. But the question is, these type of issues not only the related to quality, quantity, price, condition, mode of payment, logistic, or delivery of goods, or maybe contractual some provisions, or stipulation time period, or avoiding litigation. These are the some of the broader issues are there. But even in broader issues, some limitations are there. I have already focused what are the limitations of court of law of litigation. If you go through court of law of litigation, it's time consuming, the dates of hearing may not be convenient both parties, and judge and experts are not expected to complete in expertise in the line of international trade. Even if judge are not know about the international trade, what are the real problem is arises in the international trade and commerce and business, and some court proceedings, and some of the secrecy are not to be more focused, and some bitterness is arises, some breach of commercial relations between parties, and to foreign courts, it is difficult to go for foreign. It is litigation is very costly enough. These are the some of the negative point of a limitations of a court of litigations. But some positive point of arbitration is there. Advantage of arbitration, some positive point is, through arbiter here is a mediator is there, and the mediator can solve the problem. How it is possible? Now it is possible through a completed with time limit. It is very quicker to solve the problem, and the cost and expenses are very less as compared to the court of litigation, and it promotes goodwill also, better trade relationship also, and also the parties can avail the services also, and it will grow sometimes the possible in a court of litigation is very not enough. In such a case, arbitration is there, means the mediator is there and arbitrator is there. The arbitrator may be an individual, maybe a institution, or maybe a firm. You may call it as arbiter. It's a privacy, secrecy can be maintained, or proceedings can be done, and it's a flexible one rather than the litigation. These are the some advantage. But my dear students, if you talk about issues of settlement of international trade disputes, some of the laws are already very much important or more focused area we can consider enough. One is applicable to substantive law, similar lines of laws what are there. Jurisdiction or the forums are important. Some of the forums they can ask about, like the Human Rights Commission, are applicable to procedural law is there. Recognition and enforcement of foreign judgment and arbitral awards is there. Law of enforcement foreign awards in India there, and enforcement of Indian awards in foreign countries there. In a, means the and so as well as the currently the governance conciliation rule is also adopted by the United Nations Commission of International Trade Law. That is called as the UNACITRL. That is called as a United Nations Commission on International Trade and Law is there, and they can within this govern we can conciliation with rules and regulation, means familiar affair we can solve it, or we may solve through court of law, that is called as a litigation issues, or we may solve the third issue parties, that is may be called as arbitration. But the question is here, question is what is the overview of Indian arbitration and conciliation act 1996 and relevant for international commercial arbitration and conciliation. Means international arbitration and Indian arbitration and conciliation. What is the 1996 and how far we are equipped with internationalization? Here the question is arbitration and conciliation in 1996. The proceedings is all related to arbitration law in India 1996, and we are in such a way relevant to the international commercial law and conciliation. And so one new act is there, that is in Arbitration Act 1940s, which is and Protocol Convention 1937. Then Foreign Award Recognition and Enforcement 61 is there. These are the some acts which can conciliation with it. Conciliation means we can agree points with, or we can friendly agree with some points of internationalization as well as in Indianization. Means we are both integration of laws in relation to the two aspects. But the question is here, there are different type of sections are there. One is a important feature of new laws on arbitration or conciliation. Some of the important features are there. One is conciliation section 61 to 81. These are the some laws related to recognition to conciliation is there, and this relates to the ADR, American Depository Receipt and Mechanism Settlement Commercial Dispute is that to be taken up, and unified legal framework is also there to a fair and efficient settlement dispute is there. Arbitration agreement section 2 to 7 is there, that is called the new arbitration act, written agreement between the two parties and name is there. Another one is fourth one is applicable law is there, and the new law will be introduced with the freedom to choose applicable to substantive law or absence of choice of arbiter is there. It means some of the laws related to taken over into consideration with the internationalization with the Indian position. Another fifth point is the appointment of arbiter is necessary according to section 1996 of section 10 to 15. The Act of 1996, it is freedom to appointment of arbiter is there to determine the number of arbiter and do not determine the number of issues also there. Another one is validity of arbitration clause is there, section 16. So new laws which clarify, specifies the arbitration or forming part of a contract is there. It is independent in nature to mediator on null and void. The contract is also agreed. But even if these sections, some other sections are also there. That is called as the conciliation section 61 to 81, unified legal framework, arbitration agreement 2 to 7, applicable law, appointment of arbitrator 10 to 15, validity of arbitration section 16, powers of arbitrator that is section 16, conduct of arbitration and procedure section 18 to 27, regarding award that is section 28 to 36, venue of arbitration section 20, judicial intervention 8, 9, 11 that is a section there, and enforcement of foreign award that is 40, 44 to 60 is there. But my dear student, even if these points are there, but somehow in a negotiation, if you talk about negotiation or resolutions, there are some point of negotiations and resolutions are there. That is a negotiation of strength, negotiation of a bargaining process, and behavioral aspect of negotiation, bilateral, multilateral agreements, and corporate citizenship is there. In this case, some of the negotiation issues we can address upon. And if you talk about international agencies in a conflict resolution, in a like as a some dispute is arises, some international agencies are there. They can also solve such a international views or addressed. That is called as a United Nations Code of Conduct for Transnational Corporation 1983 is there. Means it is a comprehensive set of recommendations regarding the behavior of not only the MNC or host countries, preventing with the conflicting also. And they are also focusing with the sovereignty of a host countries, adhering the nations of economic, social goal, observing and domestic laws are there, or respecting the with the human rights also. We are always respecting human rights and corrupt practices, disclosing information of host government. These this code of conduct is called as the United Nations Code of Conduct for Transnational Corporation 1983. This is solved through internet. These are the international agencies which solve through conflict resolution. My dear students, another one is there that is called as the UNCTDAD. UNCTAD codes. What is UNCTAD? It means United Nations Conference on Trade and Development Codes. United Nations Conference on Trade and Development Codes. It includes also there is some of the restricted practices has to be controlled. What are the restricted practices? Flexibility in relax of laws, business practices to be relaxed, regarding the foreign investment, regarding the technology transfer issues, regarding the developing countries positions issues. These are the UNCTAD is there through which the particular issues can be addressed upon. Another one is there that is called as a international agency as related to conflict resolution. That is called as a the OECD Code of Practice on MNC Operation. The OECD, the OECD that is also another organization we can focus on towards the positivity of the economic and social development of a home countries, and we can some of the contribution to the host country, science, technology, dominance of positions. These are to be more focused towards the internationalization of resolution disputes. My dear students, these are the overall issues as regards to the legal environment and legal issues, and through which some of the resolution, some of the focus areas we can more pointed out, and some dispute settlement schemes are there. That dispute settlement through like as a litigation it can be solved, like as a arbitration authority is solved, like as a conciliation it can be solved, or some of the contracts are also focused, the law of contract, the sales of goods act, the proper law, or that is called as the proper law of contract, that is called the lexia, and these are the more focus upon the related to in justice upon the internationalization of business. But my dear students, if you talk about the internationalization of way of business, you should know about the international guidelines as regards to convicted upon the such type of issues. These are the topics in today's class, and I hope you may already complete yeah, the particular topic I have already completed, or you may be know about how the particular the legal guidelines which are to be framed out or different laws, like as a civil laws, like as a theoretical law, theoretic laws, or like as a so through laws which is helpful for your internationalization of business. Thank you once again. And my dear students, if any doubt, you may put through the chat box, or if you want to my PPT, you may I may share my phone number through which you can get the particular type of. One student is asking, sir, what are the advantages of arbitration? Discuss. Arbitration and litigations. Here, difference between litigation and arbitration. My dear student, litigation means it is a rule, legal tender of action like as a court of law, and arbitration is a through mediator. It can be solved. So which is used now? Which is used, that is which is beneficial? I may say only one thing: arbitration is a best point through which the particular type of business may carry in a smoothness way. I have in my PPT, you may see there are some of the negative side I have pointed out in litigation issues, and some of the positive point I have focused through the arbitration issues. So arbitration is a mediator through which the particular internationalized business can be solved in a different way, or you may called as a, that is called as a through this way it can be a greater extent it can be solved, that legal issue, that is called as arbitrations. But if you talk about in both, another one is a lex cause. Lex cause is also other name of the proper law. Proper law means that is called as a one is a, 1 minute. Proper law, it means somehow we may consider the law of contract or goods of sales of act is there, but in a proper law we may consider that is called as a